Our first argument of the morning is State v. Frum. Each party has 15 minutes to present their argument. The appellant may reserve up to 5 minutes for rebuttal. Counsel, how long would you like to reserve?
2 minutes, please.
2 minutes, very good. As you well know, the time is up there to your right. I will try to give you about a 1 minute warning if we get there. Counsel will do the same for you when we get to that point in your argument, even though the time is there. Try to look just at the top for you.
Okay.
Very likely you'll be in the middle area there. The argument being recorded. When you present your argument, please introduce yourself. Stay behind the podium and please speak loud enough so we can record you. You should not need the name of any child, minor, or victim during your argument, as I don't think we really have that in this particular case, to be doing that. But if you would refer them by initial or term like the child. With that, we read your brief and I'm ready to proceed whenever you are.
Good morning, Your Honors. May it please the Court, Joseph Schell on behalf of the appellant, Mr. Donald Frum. Your Honor, I'll reserve 2 minutes for rebuttal. So in some ways, this is an easy case. The city has conceded our second assignment of error. That not only did the city produce insufficient evidence at the hearing of a valid court order that Mr. Frum was subject to, but in fact that it necessarily couldn't, because the only order that purported to put him on probation in the first place was only signed by a magistrate and never adopted by the trial court judge. So that concession resolves the case. I'm also aware that the court need not accept the concession if it wants to, so I want to make sure that, if the court has any questions about that second assignment of error, that I'm able to answer them. But I also want to address some of the due process issues on the first assignment of error, because they don't affect just Mr. Frum in this case, but I think the court will see there's a small wave of these contempt appeals that are coming before the court here over the next few months. And I think while there are slightly different legal issues in all of them, there are some commonalities also, and I want to address two of them. The first is sort of the nature of these contempt complaints, and then the second is whether the rules of evidence apply at these indirect criminal contempt proceedings. So on the complaint, these contempt complaints are sort of walking lacks of notice in that they are very confusing to read from top to bottom and understand as a defendant exactly what you've been charged with. And that's because at the top, they specify a date, right? So here, Mr. Frum's contempt complaint here is at record page 27, right? It says that on November 25th, 2024, he didn't do something. Then there's a list of 7 check boxes for what exactly he allegedly didn't do on November 25th, right? And that can be failing to report to jail or CAST, failing to pay your fines, failing to complete community service, failing to abide by terms of probation, failing to appear, and then there's a line for other.
It seemed from what I could gather from the hearing that the prosecutor's office seemed to view that as we're filing a complaint as of November 25th, and you haven't complied with terms of probation. Not necessarily November 25th, but you didn't show up at phone call, you didn't have your phone call, you didn't do these things. That seemed to be what they were intending. You would say, obviously, that just is unclear based upon what's filed.
Yeah, I agree that does seem to be the position. It seemed to be the court's position also, but right, that's not clear from the complaint, because it does say on November 25th, not as of November 25th or anything like that, right? It says on this date, you failed to abide by the terms of your probation. And then there's also, like, underneath that though, then there's also the additional condition that you failed to appear on that date. Okay, well, failure to appear is also one of the 7 check boxes. So if that's not checked,
they could have checked if that were the issue. And it seemed to me that they're checking, at least from the example we have here, one being failed to comply with probationary terms.
Yeah.
Or there's also one, I think, in the first one that was dismissed, where they checked failed to complete summit link or drug treatment or something to that effect.
Yes, they also checked, right, that's right. In the earlier dismissed complaint, there was a box checked for failure to complete a treatment program. I think that's confusing too, because if you're ordered to do summit link, or even if you're ordered to do community service, right, which is another checkbox, the court has to put you on probation to have jurisdiction to sort of hold you to those things. So are those terms of probation, or are those separate things?
If
right,
done, you talked about if done right. In this case, the judge had signed the order.
Yes.
And said community service was supposed to have been done. I don't remember if community service was ordered in this case.
Yeah, it wasn't. But
let's say they check judge, they do it right, the judge checks community service, and then they file this box and say didn't do community service. Other than the argument that it says on November 25th or whatever day. If it didn't have a date on the top and they just said failed to do community service, you would say that gives a person adequate notice.
I think that's right. Now, I think, what typically happens, or like what happened in this case, is that, let's say in the original order, somebody's ordered to do community service, and they're also placed on a year of probation, right, for the time that they're supposed to do that community service. And then the contempt complaint checks only the failed to abide by terms of probation box, doesn't check the fail to complete community service. Okay, well, community service seems to be a term of probation because that's the only way that the court can sort of hold you to that, but failure to complete community service isn't checked on the contempt complaint. So is that what we're supposed to be preparing for at the contempt hearing or not? It's unclear. And I think the city's position here is that, well, failing to abide by the terms of probation is sort of a catch-all. But that doesn't really make sense if it's in a list with 6 other things, right? And especially in a case where, like you brought up, Judge Stevenson, that earlier, if you're charged with both, failing to complete a treatment program and failing to abide by the terms of probation, and then a later complaint only checks the probation box, okay, well that says to me, right, as Mr. Frum's attorney, okay, they're not bringing charges about, this contempt complaint is not about your failure to complete a treatment program, because he did do the Summit Link evaluation also here, right? So like it's just confusing sort of all the way down. It's not helped, like I said, by the last sort of failure. You also failed to appear on this date that's sort of pre-typed and is part of all of these complaints. It's just confusing. It doesn't really give the defendant notice. We cited, I don't have it off the top of my head, but we cited some examples in the brief where the trial court has explicitly said, what the probation term is that you've been charged with violating. And I think that's at least best practice, if not sort of what's required by due process to be notified of the actual charges against you, so that any defendant, Mr. Frum, us as his attorney, right, any other defense attorney can adequately prepare for that hearing, right, which is a criminal hearing in nature.
Has the municipal court here been willing to continue matters in your experience if there's some argument that, based upon this unclear complaint, I was unable to prepare for this, I didn't know what the issues are? When you get there and find out exactly what they are?
So, anecdotally, no, and this is going to be an issue in the Nishimiya Davis appeal coming up next month. But there was, no, I think even then when we sort of put the court on notice that we're unclear what exactly the charges are here, that didn't make a difference as to whether
did that happen in this case? Was there any attempt to continue or request from the court to make it more clear, the probation office, I guess, the state, to make it more clear before the hearing?
Not that I know of, not on the record, at least, right? What was on the record was just to make sure that because I think the trial court had started the hearing here saying that we're on a show cause hearing, and then there was some attempt to clarify, well, that's not appropriate. We were prepared for a contempt hearing. There are different rules that apply to a contempt hearing than a show cause hearing. So let's be clear about what, right? Just some sort of level setting at the beginning. And the trial court did agree that, okay, this was a contempt hearing. Now, that's not how it unfolded, though, and that gets to the second point that I want to address, these rules of evidence point. Both the trial court here and the trial prosecutor took the position that the rules of evidence don't apply at indirect criminal contempt proceedings. So as far as I know, the 8th District is the only court to have addressed this squarely, and that's in Cleveland versus Patterson. It's a 2020 case. And what it said there is, and it takes this from the text of the rules of evidence, which is the other support for why I think the rules of evidence apply, is that under Evidence Rule 101D4, it exempts only summary contempt proceedings, or proceedings in which the court can act summarily, right? And that's direct contempt, where you don't need to file a complaint, right? The contempt happened in front of the judge. You don't need all these other procedural requirements sort of fall away, right? You can hold somebody in direct contempt. But indirect contempt, requires everything that goes along with normal criminal trials and charges, except for a jury trial. Everything else is the same. You're presumed innocent. You have to be proven guilty beyond a reasonable doubt based on evidence that's introduced at the contempt hearing. And the fact that the rules of evidence specifically exempt direct contempt proceedings suggests that, okay, indirect criminal contempt proceedings then are not exempted, and that makes sense. If we're going to put somebody in jail potentially for being in contempt, it should be, then there should be some strict rules about the procedures by which we do that. and the rules of evidence help with that. It's certainly part of it. And so it's not squarely an assignment of error in this case. It is, we did raise it under our due process, both under sort of the due process argument, and we raised it under the second assignment of error as sort of an evidentiary basis on the sufficiency point. But I think, it would be helpful if the court would clarify that the rules of evidence do apply in direct criminal contempt proceedings to prevent these sort of issues.
In this case, that concern would only extend to the potential violation of the summit link evaluation. The officer could testify to, didn't call me, didn't do anything that, as the officer did in this case, that's clearly not hearsay.
That's right. Yeah, it would. Yes, it goes to the treatment program here, and yeah, that's right. That's the only thing.
And there was, in this case, at least an order signed by Judge Hamilton to do the summit link evaluation function.
Yes.
That was signed, but the other order wasn't.
That's right.
And as I understand it, I've not had a chance to read the exhibit, your client completed the evaluation?
Completed the evaluation. There was an allegation that he didn't do follow-up that was required after the evaluation.
And is that was there a written document that indicated that report, or that just the hearsay testimony of the probation officer? Do you recall?
Just the hearsay testimony of the probation officer. She testified that from a memo that she had sent to the court that was not introduced in evidence, and that was based on conversations she had with an Oriana House employee who also didn't testify.
So that memo was drafted by her, there was nothing in writing from Oriana House saying what it is, to your recollection?
There was one memo drafted by somebody from Oriana House, and there was another memo, there was a second memo, I think, drafted by the probation officer who testified.
And neither of those memos were introduced into evidence?
Correct. Yeah, that's right. So I think, so yes, I guess there's another confusing part sort of about notice in this case that's, I guess, worth talking about, is that on the magistrate's initial recommendation, so on the line for complete summit link evaluation and follow-up recommendations, the magistrate circled just the summit link evaluation on that box, which, okay, I don't want to get nitpicky here, but why do that if what you're requiring is everything on that line? Just check the line. Everybody can see that on this judgment entry form, okay, you've got to do the evaluation and follow up. Circling just one of them could suggest, that, okay, when you do the evaluation, you've done what I've ordered you to do. Now, arguably, the follow-up treatment could be a condition of probation. I grant that, right? And I think that's sort of the thrust of the city's argument, here on appeal, is like, well, the statute authorizes drug treatment as part of could be a probation condition. Yeah, and could be a probation condition, yes, absolutely. But was it in this case? I don't know. I don't know based on the magistrate's recommendation, even if that had been adopted by the judge. And I don't know because nobody introduced any evidence of the terms of probation at the hearing, other than Officer Smith testifying that Mr. Frum was supposed to answer her phone calls when she called.
About a minute left in your time, Counsel.
Yeah, so I don't really have anything else. Like I said, the concession on the second assignment of error resolves the appeal, so if the court doesn't have any questions, I'll reserve the remainder of my time. Thank you, Your Honors.
Thank you.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron. This is fairly straightforward since we have conceded error. Our concession on the second assignment of error, I think, does make the first assignment of error moot, but I'm happy to answer questions on any level of this. I would say also, for the most part, agree with the appellant here, which is that, was this the best possible way to go about the contempt proceeding? Probably not. But the reality is, there's a difference between, is this the best possible way, and was this sufficient for purposes of due process, and also sufficiency of the evidence if there was a valid court order that existed? And the answer on those, as we argued, would be yes. But again, we don't think there's a valid underlying court order here. But I do want to point out that this form that is checked off is actually not created or used by the prosecutor. It's something that is done by the court itself. The court itself is issuing these contempt orders. Notices.
So when you say the form, we're talking about the contempt complaint, for want of a better thing to call
Yes.
it. That's a court design form.
That's a court design form, and I believe the person who is signing that in this case is the bailiff for the judge.
Okay.
And I apologize, like Mr. Shell has said, like, there's a couple of these that are coming. And it's just, I think that in this case, it was the bailiff that signed this one, and they choose what boxes to check off. And they're, sorry.
So that's okay.
Yeah.
So the procedure, it sounds like to me, if I'm understanding, is the probation officer prepares some form of a memo, sends it up to the court, and then the court bailiff somehow signs as contempt if the court wishes to proceed?
Correct. That is my understanding of what happens here. And again, I think that there's some possible issues with that process, but again, the difference between could this be done a different way versus is this actually constitutionally infirm is a little bit, those are two separate issues.
Well, it's not an issue before us now, so I don't know that we're going to address that, but I understand certainly the prosecutor's office is concerned about that to extent. One thing I guess I would ask when you say you agree the hearing could have been done better. Counsel is suggesting that there is reliance on hearsay in these hearings, and that is error. Do you believe there is, A, they're reliant on hearsay, and B, does the state believe that that is problematic in these cases?
I will say that this objection was made specifically in this hearing and in the subsequent appeal that's coming. And in both cases, the prosecutor took the position that that rules of evidence do not apply in the contempt proceedings, and the judge agreed. I do not have an argument for why that would be correct. I think that this is an issue that if it was addressed by the court, it would be helpful, but at the same time, I'm not sure it's directly before you, given the issue of the actual underlying order not existing.
So as I understand it today, then you're conceding that there is no valid order for probation in this case?
Correct, Your Honor. There's no final sentencing order at all. And that's a issue that, again, I think comes down to the fact that there's a lot of use of forms, and the use of the forms is in some ways causing some of the problems that exist here. And I understand why, there's a lot of volume that comes through the court, but it's the same time that the confusion with that contempt order, like we put in our brief, if you fail to comply with probation, that includes everything in that list. And I understand they're saying, well, if you have it on the list, you should check that off too, but it is a most superfluous checkbox. And again, maybe the form should maybe be written differently, or these things should be typed up separately. I think that would maybe clear up some of the issues, but again, I think it's not constitutionally infirm, given they know the notices, you fail to comply with probation, and then you get an opportunity to be heard with a contempt hearing. Of course, there's also a question, should these even be contempt hearings, as opposed to probation violations, proceedings? And that's another issue that I believe is in a third appeal that's coming up at some point between our offices. So that is the world that I see it in this case.
We certainly appreciate your candor in this case and being straightforward about what the record shows about these orders, because it is difficult for us in part because we're dealing with signatures who, without a name underneath, it's unclear who did or didn't sign these. And I am the last person to talk about clarity of a signature in this world, but the signatures aren't always clear. So certainly on that, and we're not judging those future cases that come up in any way, shape, or form. We deal with those cases. So I appreciate your candor and your thoughts on the issues as well.
All right, thank you. If there's no further questions, I'll rest.
See, no questions.
I'll wait for rebuttal, Your Honor.
All right, very good. Thank you. Thank you both for your presentations on behalf of the court. The court will take the matter under advisement and issue a decision in due course. The clerk of the court will mail a copy of that decision to you on the day of the release, and also the opinion will be posted on the High Supreme Court website. Again, thank you very much.